If you've been in a Florida car accident and the insurance adjuster's friendly offer doesn't come close to covering your real damages, you're not alone. When you know the strategies that experienced injury lawyers use every day, you can push back against lowball tactics and position yourself for the settlement you actually deserve. Because if you take the wrong steps in the first weeks after your crash, you could lock yourself into a payout that leaves you paying for medical bills out of your own pocket. Hi, I'm Pablo Tamayo, and I've been a lawyer practicing law in South Florida for just about 2 decades. And I can tell you that the insurance companies have one primary goal: pay out as little as possible while getting you to sign that release as quickly as they can. Today, I'm going to share 5 specific strategies that will help you avoid getting lowballed and position yourself to recover the compensation you actually deserve. These aren't theoretical concepts. They're strategies I use every single day when I'm negotiating with insurance companies on behalf of my clients. The first settlement offer from an insurance company is almost always their lowest offer. It's a starting point designed to test whether you understand the value of your claim. In Florida, insurance adjusters are trained to make initial offers that are typically 10 to 20% of what they're actually prepared to pay. Here's what most people don't realize. That first offer often comes before the adjuster has even received all of your medical records or fully investigated the extent of your damages. They're just hoping you'll take the quick money and walk away before you understand the full scope of your injuries. We've handled numerous cases where a client comes to us after being offered maybe a few $1,000s from the insurance company. Most times, they're tempted to take the money, but they don't have any idea what their case is actually worth or the full extent of their actual injuries. Once we've taken over representation of those cases, we usually end up settling their cases for many multiples over what they were initially offered. The key is patience. Don't let the insurance company pressure you with phrases like, "This offer expires in 48 hours," or "This is all we're authorized to pay." That's nonsense. Insurance companies have plenty of money, and they have the authority to pay fair settlements when you demonstrate the true value of your claim. Insurance companies love to dispute what they can't see documented. If it's not written down, photographed, or recorded somewhere, they'll argue it didn't happen or isn't a direct result from your accident. Start with the accident scene itself. Take photos of all vehicles involved, the road conditions, the traffic signs, any skid marks, or any other debris. Get the other driver's insurance information, driver's license, license plate number. If there are witnesses, get their contact information immediately. But documentation doesn't stop at the scene. Keep a daily journal of how your injuries are affecting your life. Are you having trouble sleeping? Can't lift your child? You're missing work? Write it down. These details become crucial when we're calculating your pain and suffering damages. Save every receipt related to your accident. This includes medical copays, prescription costs, physical therapy sessions, rental-car expenses, Uber lifts, and even mileage to and from medical appointments. Under Florida law, you're entitled to recover these out-of-pocket expenses, but only if you can prove them. I tell my clients to create a dedicated folder for their accident case and put everything in there: medical records, correspondence with insurance companies, repair estimates, work excuse or doctor's notes, everything. This documentation becomes the foundation of your case and makes it much harder for insurance companies to lowball you when they see you're organized and serious. Florida operates under a no-fault insurance system, which means your own personal injury protection coverage, or PIP, pays for your initial medical expenses and lost wages regardless of who caused the accident. But here's what many people don't really understand. PIP only covers $10,000 in medical expenses and up to 60% of your lost wages. What happens when your damages exceed your PIP coverage? That's what is considered as part of your claim against the at-fault driver's insurance company. But there is a catch. Under Florida Statute 627.737, you can only step outside the no-fault system and recover for non-economic damages if you meet certain thresholds. You can recover additional compensation if your injuries result in significant and permanent loss of an important bodily function, permanent injury within a reasonable degree of medical probability, significant and permanent scarring or disfigurement, or death. This is why proper medical documentation is so critical. Insurance adjusters for the at-fault driver will often try to settle with you before you've reached maximum medical improvement. They're hoping your injuries won't meet the threshold requirements or that you won't understand your rights under Florida law. Don't let them rush you into a settlement before you know the full extent of your injuries and your future medical treatment requirements. Within days of your accident, you'll likely receive a call from the other driver's insurance company asking for a recorded statement about what happened. They'll make it sound routine and harmless. We just need to get your version of the events for our file. Don't do it. These recorded statements are designed to lock you into a version of events before you've had time to fully process what happened or consult with an attorney. Insurance adjusters are skilled at asking leading questions that can damage your case later on. For example, they might ask, "You're feeling better now, right?" If you say yes, because you're having a good day or the pain isn't as bad as it was the day before, they'll use that statement to argue that your injuries just aren't that serious. They might ask you about pre-existing conditions or other accidents in a way that suggests that your current injuries aren't related to this particular accident. In Florida, you're under no legal obligation to give a recorded statement to the other driver's insurance company. You are required to cooperate with your own insurance company as part of your policy agreement. But even then, you have the right to have an attorney present. I've seen too many cases where a client's recorded statement comes back to hurt their case. Do not be mistaken. The insurance company will try and use your statements against you. Protect yourself by politely declining to give a statement and directing them to speak with your attorney. Most people think that their car accident claim is just about medical bills and car repairs. But under Florida law, you may be entitled to recover much more than that. The problem is, if you don't know what you're entitled to, you can't negotiate for it effectively. Your total damages might include past and future medical expenses, lost wages, diminished earning capacity, property damage, or also pain and suffering. Pain and suffering damages can be substantial, but they're also the most subjective and the hardest to calculate. Florida courts have established that pain and suffering damages should compensate you for physical pain, mental anguish, inconvenience, and loss of capacity for the enjoyment of life. Pain and suffering damages are designed to provide solace for grief and comfort for worry. But how do you put a dollar value on that? Insurance companies will often use computer programs that spit out lowball numbers based on your medical expenses. They might offer the cost of your medical bills. They even have their own way to calculate the value of your medical bills. And these formulas don't account for how your specific injuries have impacted your unique life circumstances. I have routinely handled cases where we have recovered multiples of what the client was first offered by the insurance company. Each case is different, but a big difference was understanding the full scope of what Florida allows you to recover. This is why it's so important to have someone evaluate your case who understands Florida personal injury law and has experience negotiating with insurance companies. They know the tactics adjusters use, and they know how to counter them effectively. Look, dealing with insurance companies after a car accident, it's like playing poker against professional gamblers while you're still learning the rules. They have teams of adjusters, investigators, and attorneys whose job it is to minimize what they pay you. You need to level the playing field. The 5 strategies I just shared with you will help protect you from the most common tactics insurance companies use to lowball accident victims. But there's so much more you need to know about maximizing your settlement, especially here in Florida, where we have specific laws and procedures that can dramatically increase your recovery. In my next video, I'm going to reveal 5 secrets to substantially increase your Florida accident injury settlement. These are advanced negotiation strategies that most people never learn, but they can make the difference between a settlement that barely covers your expenses and one that truly compensates you for what you've been through. Some of these secrets involve timing your settlement demand in specific ways that insurance companies hate, and others involve leveraging parts of Florida law that most adjusters hope you never discover. If you're serious about getting the maximum compensation for your accident, you need to watch that video as soon as it goes live. Your case won't wait, and neither should you. See you over there.